Welcome to another episode of the Federal Newswire Lunch Hour Podcast with your host, Andrew Langer.
Well, hey there, everybody. Welcome to another episode of the Lunch Hour with Federal Newswire. I'm your host, Andrew Langer, and I want to thank you all for tuning in. If you're watching us on YouTube, you can always listen to the show when you're out and about, wherever fine podcasts are purveyed. If you're listening to us and you want to catch the video and see what I look like in studio, what my guests look like, check us out on YouTube. Very excited to have our guest join us today. His name is Ilya Somin, and I'm going to read this. I'm going to look down. He is the professor of law at George Mason University and the B. Kenneth Simon Chair in Constitutional Studies at the Cato Institute. His research focuses on constitutional law, property law, democratic theory, federalism, and migration rights. He is the author of Free to Move, Foot Voting, Migration, and Political Freedom, Democracy and Political Ignorance, Why Government is Smart, Why Smaller Government is Smarter, and The Grasping Hand, Kelo versus the City of New London, and The Limits of Eminent Domain, a case that is near and dear to my heart. Somin's writings have been cited in decisions by the United States Supreme Court, multiple state Supreme Courts, and lower federal courts. He writes regularly for the Volokh Conspiracy, a popular blog now housed with Reason Magazine, used to be at the Washington Post. He earned his BA summa cum laude from Amherst, his MA in political science from Harvard, and his JD from Yale, so he is from a mixed marriage in terms of his education. And he's also, I want to start here, Ilya. We've talked with your colleague and friend, Ilya Shapiro, the other Ilya. I haven't had them on the podcast yet, but I've also interviewed both of the Volokh brothers, Gene and Sasha. Sasha's been a friend of mine for a long time. All of you share this heritage of having emigrated to the United States. And I want to ask you this. Talk about your background now, Russia, then the Soviet Union. I recall, I think you migrated from the Soviet Union. Talk about how this informed your journey in terms of your scholarship and shaped your beliefs, your legal values.
It's hard to know for sure because obviously we can't really know what would have happened if I was exactly the same as I otherwise am, except that I grew up in the United States or in some other country and had never been born in Russia, then the Soviet Union. I think, and this is just conjecture, that to the extent that it has affected my worldview, it has done so in two ways. First, I think I'm the kind of person who temperamentally, if they had grown up in the West or lived in West their whole lives, would be more likely than not to be on the political left, because I'm an intellectual type of person. I have policy wonk sort of tendencies and the like, and certainly not everybody like that who grows up in the West or who lives their whole lives there tend to be on the left, but a majority are like that. Secondly, I think being a member of what in the Soviet Union and to some extent still in Russia today is an oppressed minority has also made me very negative about nationalism of various kinds. I might have had that trait, I think, even if I had lived my entire life in the U.S., but I think it's even more so because of my actual background, and that has made me more hostile to nationalism even than many other libertarians are, because I think some libertarians are overly tolerant of nationalism because they see themselves as generally on the political right, and therefore, just as there are people who have a sort of no enemies on the left kind of mentality, there are some libertarians, not all by any means, but some who have more of a no enemies on the right mentality, and so they give nationalism more credence and credibility than it deserves.
Well, you're right. Certainly, if nationalism leads to greater statism, that's a problem, right? The enlargement. I said this. It's funny. I wrote an essay last week oh good Lord, for constituting America, and it was about the First Amendment and the right to petition your government for redress of grievances. And one of the things I talked about was the issue of the push-pull between the enlargement of government and individual rights. And one of the things that I said was every time government is enlarged, individual rights are diminished. And then I used the phrase, you can't reconcile liberty with anti-liberty. And I want to get your thoughts on that and how you see the push-pull there.
So I think what you said is basically right. I don't know if you can say it's always true that every single enlargement of government always restricts liberty. I think there are exceptions, but the exceptions are relatively rare. And the rule is when government spends, regulates, and controls people more, the vast majority of the time it really is inimical to liberty. Moreover, the more it happens, the harder it is to sort of keep it under some kind of control, prevent slippery slope dynamics, and so on.
Do you get alarmed? Are you alarmed as someone whose family migrated from the Soviet Union and who values freedom as highly as you do? Do you get alarmed? Again, we can set aside the nationalism on the right for a second. We can talk about that later if you want. But do you get alarmed on the left with this greater devotion, almost ever more great devotion now than there has been in recent memory, towards Marxism or the various flavors of Marxism that seem to be becoming more present? The idea that socialism can work, it just hasn't been tried properly. What are your thoughts?
I actually think that Marxism as such has not become more prevalent on the left in recent years. To the extent that we've seen a rebirth of socialism, it's actually mostly non-Marxist forms of socialism. And we can talk about how these things differ if you're interested.
100%.
If you look at the growth of socialism by people like Jeremy Corbyn in the U.S., in Britain, and Bernie Sanders in the U.S. and others, interestingly, rarely are they devoted to any kind of distinctively Marxist concepts like class struggle, inevitable stages of history, and the like. Or in some cases, they even claim that they're not actually going to have government ownership of the means of production, as almost all actual Marxists advocate.
Sure.
Instead, what they say is that we can have socialism in the sense of very extensive government control of the economy and civil society and the like, but it won't take the classical Marxist form that we saw in the Soviet Union or in China and the like, and therefore will avoid those problems. And I have argued in some of my writings that this type of socialism, while as a theoretical matter it may have different foundations than Marxism, it has many of the same problems. In particular, even if it does avoid direct state ownership of the means of production, it requires a takeover of so much of the economy as to effectively make the government the entity controlling it, thereby raising the same sorts of problems of abuse of power, lack of adequate knowledge, and other kinds of issues as more traditional Marxist socialism. And on top of that, I dispute claims that this form of socialism can remain democratic, as advocates of it say that it can. And even if it could remain democratic, it would still be very dangerous and problematic. But I actually disagree with those on the right who say we've had a resurgence of Marxism.
Sure.
For the most part, that's not true unless you define Marxism so broadly that the concept no longer is useful.
Right. If you use Marxism as a shorthand for socialism generally and the various flavors of socialism, that I understand. Let's talk a little bit about the other side of it. So the intersection of corporate and state power, right? When corporations start to do the bidding or the actions of government, and then what China has been not just flirting with but engaging in, the concept of a government-run social crediting system. How does that all play in our society, in the American society today? The whether or not it's the issues of censorship on social media platforms, or whether it is the government policy of dinging people if they have a good credit score, all of the folks who've proposed limiting travel options based upon carbon footprint or your background. Or where do you come down here? Where do you sort of how do you noodle this through?
So that's a sort of a whole bunch of different issues, some of which I think
I
agree with you on, others not.
And you don't have to agree with me on everything.
But
I want to get your thoughts.
But to step back from the specifics to more general, I think on the one hand, analogies between anything going on in the U.S. and the Chinese social credit system are overblown. On the other hand, there is a tendency on both left and right to want to try to get businesses, particularly but not exclusively large businesses, more under government control in order to promote, on the left, sort of a more left-wing agenda, on the right, a nationalist or a social conservative agenda. I condemn that when Elizabeth Warren advocates it. I also condemn that when people on the right, like Ron DeSantis and others, try to do similar things, like their efforts to try to attack what they call wokeness in corporations, their efforts to get social media platforms to host speech or people that those platforms would like to exclude. In my view, both the left and the right would do better to leave these issues to competition and individual choice in the free market. Actors in the market will sometimes make choices that we do not like, but if they do, we have the option of voting with our feet and engaging in competition and choice, whereas when government imposes a single unitary standard, whether it's a left-wing standard or a right-wing one, then that choice is taken away from us, and also various other harms follow.
Yeah, we had Jessica Malugin from the Competitive Enterprise Institute on recently, and she's talked quite a bit about this idea of throwing out the baby with the bathwater. Just recently, a congressional hearing on artificial intelligence, in which there was some suggestion that maybe you have the founders of ChatGPT calling for greater regulation. Actually, let me ask you about this: the issue of large corporate entities calling for greater amounts of regulation. Maybe we're getting too far afield here, but I would love to get your thoughts on this. Using the power of government as a tool to shut down competition.
This is not a new problem. It's been going on for centuries. There's a long history of large businesses or very established business in a particular industry pressuring for regulation that reduces their competition, because there are various regulatory burdens that large incumbent businesses can more easily bear than potential new competitors, and they're well aware of that. And so there's a long history of these businesses using public interest rhetoric and allying with various factions on the left or the right to try to suppress their competition. That's not a new thing.
Let's shift gears here a little bit. You recently wrote on the Volokh conspiracy about some suggestions that Eric Siegel has made regarding improving the discourse between folks on the various ideologies. And we've sort of led down this road because you're right, there's a huge amount of difference. Both sides tend to do the same things to one another and call for just sort of different flavors of action, tend to be mirror images in many ways of one another. But we need to be able to talk to one another. Again, one of the things that I've talked about quite a bit is, if we don't have a common heritage, then we can't really talk together to solve problems moving down the road. How do we go about improving dialogue?
So for those who may not know, Eric Siegel is a prominent left-wing law professor. He and I don't agree on very much, but it so happens we do agree on this issue. He has a list of various things to improve dialogue between left and right in the legal world, some of which might be adaptable beyond the legal world, but they're especially adaptable here. I won't go through the entire list of his proposals, but they include such things as having the Federalist Society and the American Constitution Society, the most prominent right-wing and left-wing lawyers organizations, have them host more oppositional speakers, that is, speakers that go against their views, have them do joint events and debates. He urges federal judges, and I agree, each federal judge currently hires 3 or 4 clerks, recent law school graduates, who help them draft opinions. He says that it would be good if they tried to each have at least one who is of an ideology different from that of the judge. And I agree, a person who doesn't agree with the judge's views on many things is more likely to catch certain errors than a staff member who's ideologically aligned. Most of us, more attuned to mistakes that people opposed to us ideologically make than to the mistakes of, quote unquote, our own side. And he has several other proposals as well. In my piece commenting or responding to his, I added the idea that law schools in particular should try to combat ideological discrimination in hiring because that is a significant phenomenon which in most cases, not all, but most, tends to be discrimination against conservative libertarian professors, not because right of center people are less likely to discriminate, but because there are very few right of center people in academia to begin with, and therefore they have fewer opportunities to do so than people on the left. And if you have little or no representation of an entire side of the political spectrum on the faculty, that reduces the quality of dialogue. For what it's worth, Eric has actually endorsed this proposal, and when he commented on it on Twitter. So there is a lot that can be done. None of it will make all forms of our discourse wonderful and perfect, or completely eliminate the polarization we have, but it could reduce it at the margin.
When did we lose the idea that the answer to speech we don't like is more speech? You know, it used to be, I mean, there were folks who detracted this, right? We know that you know, it's not popular speech that needs protection, it's unpopular speech that needs protection. This is why the ACLU was formed. When did we tend to lose this idea of having more speech as the answer? Or did we ever really have that as a value?
I think a lot of people had it as a value. A lot of people still do, but there has always been opposition. And I think if you look at American history, cycles of censorship or attempts at censorship occur at various times. They tend to occur during crises or during a situation like now when there is deep polarization and therefore more hatred than usual against the other side. That said, at least on the side of legal doctrine, the law is actually more protective of freedom of speech in most areas than it ever has been. So I do think some historical perspective is desirable here. There are efforts to attack it both on right and the left, but courts have actually been tougher on those efforts in recent years than they were during previous cycles of censorship, like during the 1950s, in the aftermath of World War I, and some other examples that we can mention. So in the area of free speech, things could certainly be better than they are, and there are various kinds of attacks on free speech by both the right and the left, but the resistance to those attacks actually, particularly in the judiciary, has been stronger than in previous periods of outbreaks of censorship in American history.
So let's turn our attention to a subject nearest and dearest to my heart. Actually, nearest and dearest is regulatory issues. In fact, let's start there. I want to go to property rights. But we've got a lot of attention being paid to the Supreme Court right now over the issue of deference. Yet another case coming up which will challenge the issue of Chevron, so-called Chevron deference, the idea that agencies have the discretion to interpret congressional laws, and what the agency says generally is how the courts will uphold the interpretation. What's going on in the Supreme Court right now regarding Chevron and deference, and where do you think things are going to go?
So Chevron is a 1984 Supreme Court decision where the court says that if there's a federal agency that is tasked with enforcing a law or applying it, and it interprets that law, then courts are required to defer to the agency's interpretation so long as it's reasonable and certain other criteria are met. And this is a pretty important decision because obviously we have a large regulatory state. Federal agencies interpret laws as they must on many occasions, and so this transfers a good deal of interpretive authority away from the judiciary to regulatory agencies, bureaucrats, government officials, and so forth. There have always been critics of Chevron. Ironically, early on, most of them were on the left, whereas most of the defenders of Chevron back in the 1980s, when a decision first came down, were on the political right. But in more recent years, that valence has shifted, and right-of-center legal scholars, judges, and others have been very critical of Chevron, whereas at least some on the left have begun to defend it more. The Supreme Court over the last 15 to 20 years has cut back on Chevron deference in various ways, but right now there is a case before the Supreme Court which in principle could potentially end Chevron deference, which I would favor, but I think it's at least as likely, perhaps more likely, that what the court will actually do is cut back on Chevron deference more, but without completely getting rid of it, because there is now what lawyers call 3 stages of Chevron. There is Chevron stage 2, which is when you get to the point of determining whether the agency's interpretation is reasonable. Then there's Chevron stage 1, where before you even get to stage 2, the court has to determine whether Congress has spoken to the issue.
Right.
Because if it has, then you never get to the point of deference. Deference is only supposed to apply if things are ambiguous, and what counts as ambiguous is itself somewhat ambiguous. And then finally, there's so-called Chevron stage 0, where the issue is whether the Chevron doctrine even applies to the situation. Right. For example, the Supreme Court has said that Chevron does not apply to so-called major questions. That is, when the issue is really big and really important. Of course, what counts as a major question is itself something of a major question.
Sure.
The court is not fully addressed. So in this case, it's possible that we'll get another decision limiting the scope of Chevron deference in this instance by saying that Chevron deference does not apply when it's not clear whether when Congress seems to be silent on the issue of whether this is the sort of question that the agency has within its ambit. There might be other ways as well that the court could cut back further on Chevron without getting rid of it. I think there is not 5 votes on the Supreme Court for getting rid of Chevron completely, but I hope I'm wrong about that, and then maybe the court will surprise us. We'll see.
Well, one of the answers, right, one of the great problems, and I think you and I both agree that one of the greatest threats to liberty in the United States today is the expansion of executive branch power. And one of the issues, of course, is that when Congress passes vague laws that are open to interpretation, that gives the agencies license to sort of not do whatever they want, obviously, because we've just outlined some limits there. But if Congress was just more explicit, and I'll ask you this in terms of Kelo later on, but if Congress was more explicit in how they define terms, a lot of this would be undone, but Congress doesn't want to be more explicit. They want to leave it open to the agencies to interpret, don't they?
Sometimes they do, but I also think some agency discretion, maybe even a lot, is unavoidable when Congress regulates and spends as much as it does. So modern statutes, those passed in the last 20 or 30 years, are on the whole more precise and detailed than those passed, say, 100 years ago. That's how you get statutes that are many thousands of words long. Obamacare is many thousands of words long. The various stimulus bills passed over the last 2 or 3 years are enormously long. The Inflation Reduction Act, somewhat misleadingly named, but that's what it's called. Right. That's thousands of pages long. But even if Congress is trying to be precise, given the enormous amount of stuff that comes within these bills, it's hard for Congress, probably impossible for them to foresee everything. It's hard for them not to give agencies a good deal of discretion. And therefore, it's not simply a matter of Congress sitting down on the job, or of Congress wanting to leave a hard issue to an agency so that the agency will get the blame and members of Congress won't.
Okay.
Sometimes that happens, but even if that never happened, even if Congress always tried to be as precise as it could possibly be, given the enormous scope of federal spending and regulation, there would still be a lot of issues that Congress couldn't anticipate, a lot of places where it's inevitably imprecise, and therefore agencies would have a lot of discretion. And I think if you really want to avoid a lot of agency discretion, you want to take a hard look at the size and scope of federal government intervention in various aspects of our society. And to really reduce the power of agencies, you would probably have to have a lot less of that.
There you go. That's interesting. So let's shift gears and let's talk a little bit about property rights issues. Again, the other thing that's near and dear to my heart, both regulation and property rights. Had on somebody from Pacific Legal Foundation just a couple of weeks back. Fascinating conversation. Also had a conversation with Margaret Byfield from American Stewards for Liberty, an organization that deals a lot with public lands and property rights issues. In both instances, spent some time talking about the Tucker Act shuffle. And the issues of ripeness. There is a Fifth Circuit decision that's out there right now, which is virtually going to make it impossible for folks to pursue property rights claims against state governments. You write about this, the Volokh conspiracy. Tell us about it.
Yes. So until 2019, for about 34 years, there was a Supreme Court precedent which said that you cannot file takings claims against state and local governments in federal court unless you have exhausted every possible avenue of appeal in the state courts. And if you've done that, then at that point, you still can't go to federal court because of technical legal issues which say that you can't file a case in federal court that essentially has already been decided in state court. And so this was a catch-22. Right. And in 2019, in the Nick case, the Supreme Court overturned Williamson County, the 1985 precedent, which said that, and they basically said takings clause rights claims that the state or local government has taken your property and therefore must pay just compensation as required by the Fifth Amendment. They can go to federal court to begin with, much the same way as other federal constitutional rights claims. In the Villiers case decided by the Fifth Circuit just recently, they had essentially created a very similar and in some ways even worse catch-22, and I think therefore in defiance of Nick and also in defiance of various other legal principles. This is a case where a bunch of property owners, their property was damaged by the state government of Texas. They tried to file a case against Texas, I think if I remember correctly, initially in state court, and the state of Texas used a statute that allows them to remove the case to federal court. But then once it was removed to federal court, then the Fifth Circuit decided that it can't be heard in federal court either, because they said in order to have a case about takings heard in federal court, there must be specific statutory authorization, and the relevant federal statute that authorizes bringing various takings cases in federal court, they say it covers local governments and it covers the federal government, but it doesn't cover state governments. And therefore, in effect, if you, on this theory, if you bring this case in federal court against the state government, they will say, well, there's no proper statutory authorization, but if you bring it in state court, then the state government can remove the case to federal court. But after removing the case to federal court, then they can say that there's no jurisdiction in the federal court, and therefore the case has to be dismissed. So this is in some ways an even worse catch-22 than the catch-22 under Nick. Before Nick was
Williamson
there.
County,
You can at least bring the case in state court, even if you couldn't bring it in federal court. But on this theory, if it holds, you cannot bring this case if it's a state government defended, either in federal court or in state court. And I think this certainly goes against Nick, which specifically says you cannot have this sort of catch-22, and it sort of goes against basic common sense and longstanding constitutional principles, which say that at least in vast majority of cases, you can bring constitutional cases against a government that has violated your constitutional rights, even if there isn't the specific statutory authorization. You can bring the case directly under the Constitution. Even more amazingly, the Fifth Circuit opinion, which does this, it's only a few sentences long. It doesn't even cite the Nick case, much less try to distinguish this case from Nick, nor does it cite any other relevant Supreme Court precedents in the takings clause area. There was then later an attempt to take the case en banc, that is, have it heard not just by a three-judge panel, but by the entire Fifth Circuit, which has something like, I think at this point, 18 or 19 judges in it. But the Fifth Circuit chose not to take the case en banc.
Really?
They voted 11-5 not to take it. It's
That's
not
crazy
entirely
to me.
clear why various judges who I suspect do not agree with the panel decision, chose not to take it en banc. But I suspect it's because there are many judges, including on the Fifth Circuit, who just really don't like taking cases en banc and say there's a strong presumption against it. And so as a result, I think some judges who, if the case did go en banc, would vote to overturn the panel, that some of those judges chose not to take it en banc. At this point, there is an effort to bring the case before the Supreme Court. I have prepared an amicus brief, a friend of the court brief, together with the Cato Institute, urging the court to take the case, and I certainly hope that they will.
I hope that they will as well. I mean, it gets into the issue, right? There's the famous Supreme Court case in which they wondered aloud why property rights are treated, relegated to the status of a poor relation in terms of, the other rights that are out there. Why do so many judges, why are they openly hostile? I'm reminded of, before Kelo, and we're going to get to Kelo in a second, there was a case called Jones versus Flowers, in which, Chief Justice Roberts, writing for the court, essentially told, I want to say it was the state of Alabama, it may have been Arkansas, I tend to get them confused, I apologize, essentially telling the state how to take private property. In that case, the property owner wasn't actually given due notice that the property was being taken and being put up for auction. And they were able to demonstrate that they never saw the certified letters that were sent. And Justice Roberts said, well, something, listen, if you don't want to go through the whole idea of actually giving them due process, and sending, just stop sending certified letters. Put the onus on the property owner to prove that they didn't receive the letter saying that their property might be taken from them. And a colleague of mine had said this is one of the reasons why you shouldn't trust Chief Justice Roberts, and I was inclined to agree on property rights issues. Why are so many judges hostile to them? I mean, sorry, go ahead.
So Chief Justice Roberts, to my pleasant surprise, is actually very good on most property rights issues, especially takings clause issues. But if you ask why there are many judges who are not and who tend to treat them less favorably than other constitutional rights, there is a long history to this, but it has to do with the progressive and New Deal eras, when a view emerged, particularly on the left, but even extending to some on the right as well, which holds that property rights and other so-called economic rights are first less important than other rights. They just don't have that much value as compared to, say, free speech rights or criminal procedure rights or others, but also that often they're actively pernicious, and there are various arguments that were then given and still sometimes used today as to why they're pernicious, but one is that property rights stand in the way of rational and effective government planning, that they prevent, for instance, the government from restructuring urban landscapes and other places in order to alleviate various social problems.
Heaven forfend.
There was and still is the view that really property rights, for the most part, they only benefit the rich, and if anything, they enable the rich to exploit the poor in various ways. I think both of these claims are, for the most part, wrong, but they were widely believed, including among judges, legal scholars, pillars, the legal profession, and so forth, especially during the progressive and New Deal eras, which are eras where the thought that was produced at that time still has a lot of influence in the legal world, even if the influence is often indirect, and many of the people influenced by these ideas can't necessarily trace them back all the way to their origins. I think over the last 30 to 40 years, there has been somewhat of a revival of property rights in the Supreme Court and also in many state courts, but that revival has been uneven. It's affected some issues more than others. There's even been some rethinking of these sorts of claims on the political left as well as on the right, but on the left, that rethinking has mostly gone on among people other than federal judges. The current crop of left-of-center federal judges, with some exceptions, still tends to take a sort of New Deal kind of attitude towards property rights. That may be slowly changing, but it hasn't changed yet.
It's funny. I knew I was going to get hooked on the TV show Yellowstone when, in the opening episode, the opening scene of the opening episode, it was one of the sons, who's an attorney, arguing over an eminent domain issue in Montana State Court. And it's, again, an issue that's near and dear to my heart. It's how we got, the Kelo decision, which you've done a lot of writing on. In fact, you wrote a book on it, The Grasping Hand, Kelo versus the City of New London and the Limits of Eminent Domain. You've gone back and you've been able to review some of the notes, the unfiled dissent by Justice Scalia in the case. Talk about, and now well, first let's start here. Apparently there's news that New London is finally going to develop this piece of property that has lain fallow for more than 20 years.
For those who may not know, Kelo is a 2005 Supreme Court decision, which has to do with the public use provision of the Fifth Amendment, which says that the government can only take private property if it's, quote, for a public use. And the question is, well, what counts as a public use? In Kelo, the government took 15 homes, 15 residential properties by eminent domain, and the public use, so-called, was to give it to a private developer to produce sort of privately owned development of various kinds. And the Supreme Court, when the case eventually got to them, but in a close 5-4 decision, they held that even privately owned economic development qualifies as a public use because they endorsed, as they had previously done in a couple of other cases, what I called the broad view of public use, the idea that a public use is anything that might potentially benefit the public in some way, and even the government doesn't necessarily have to prove that the supposed benefit will actually materialize, which in this case, by the way, it never did. And while Kelo was not the first decision to endorse the broad definition of public use, the Supreme Court had actually first done that all the way back in 1954, in a case called Berman versus Parker. Kelo did call an enormous amount of public attention to this issue. Most of the public, about 80% in polls, really hated this decision. There were 4 Supreme Court justices who dissented, unlike previous decisions in this area which had been unanimous. So it really kicked off a debate over this issue. And as it turns out, what happened in New London itself, the development project there was actually badly conceived. To this day, nothing has actually been built on the condemned property. The initial development plan fell through. Some later efforts also fell through. However, in January of this year, almost 18 years after a Supreme Court decision, the private nonprofit development corporation to which the city of New London had given the property after it was condemned, they have finally sold it to an actual developer who may in fact build new housing on the land. At least that's what they plan to do. I have tried to contact the developer to ask what exactly they're going to build and on what schedule, but so far they have not answered my queries. If you're listening, please tell me if it's not a secret what it is that you're planning to build. So it's possible that something will finally be built on the condemned land after 18 years or more, but during that time up to now, the only regular users of the condemned property were a colony of feral cats. So you can say we've created a feral cat shelter, but on balance, it probably wasn't worth it. I hope the new development project succeeds, but even that I think will not validate this taking, because of course the land will have lain empty for almost 20 years by the time something finally does get built, if indeed it does, and that's not a great record. Even if you don't care about property rights for their own sake, you don't care about the people who are expelled. If all you care about is just promoting some new economic development, even that hasn't actually happened, and for many years.
My favorite aspect, and I say that sardonically, was when the city of New London sent Suzette Kelo, the plaintiff, the named plaintiff in this case, sent her a letter demanding back rent for her occupation of the property while the lawsuit was going on, and saying, well, we know you obviously didn't expect to live rent-free on that property while the law... It just that maddened me. Before we let you go, because I know you're short on time, does Kelo underscore the danger of reliance on precedent, slavish reliance on precedent, stare decisis? We spend a lot of time in Supreme Court hearings, nomination hearings, talking about stare decisis. To me, Kelo is one of those great examples of why stare decisis may not be all that it's chalked up to be.
I agree. Kelo relies heavily on previous Supreme Court precedents, including the Berman case, which I mentioned. Ironically, some of the Kelo's reliance on precedent is actually misplaced, as Justice Stevens, the author of the Kelo majority opinion, later admitted. In the opinion, he famously said his decision was backed by a century of precedent. He later had to admit that wasn't true, because precedents that he cited from the late 19th and early 20th century weren't actually about the public use clause at all. I actually pointed this out in an article I wrote a year or two after Kelo came down. To his credit, Justice Stevens found out about the article, and later in a 2011 speech, he admitted that he got this point wrong, although he still, to his dying day, he believed he got the underlying decision correct. But Supreme Court justices rarely admit any errors, so it's a credit to him that he was willing to admit a significant error here. But I think you're right that there have to be times when courts should be willing to overturn precedent. There's an argument for maintaining precedent if it's only modestly wrong, or if there is very great reliance interests that have built up over time. But there should be room for overturning flawed precedents, especially if they cause great harm, and especially if they are constitutional precedents, where the only other way to overturn it is through a constitutional amendment, which under modern conditions is almost impossible to do. I would add that almost every legal thinker on both right and left agrees that precedent should be overturned at least sometimes, especially constitutional precedents. But on the other hand, they also like to cry stare decisis whenever a precedent that they like is overturned. So just as there is fair weather federalism and hypocrisies of other kinds, there's also often fair weather stare decisis that people love to appeal to it when it's a case that they like, but they're also happy to throw it out when they really don't like the existing precedent. But I think precedent does need to be sometimes overturned, and the Supreme Court might do well to develop somewhat clearer standards for when that's justified than the standards they have now, though they have tried to develop standards over a series of different cases.
Well, Ilya Shapiro, we'll leave it there. I want to thank you so very much. I'm sorry, boy. I knew I was going to mess it up once.
For those who are interested, I have a whole blog post about the subject of Ilya confusion, where I try to explain the things that distinguish me from the other Ilya Shapiro, who is now with the Manhattan Institute. Though I suspect on the issue of Kelo, he probably agrees with me that Kelo should be overturned.
I think that's very true. In fact, I think Ilya Shapiro and I have had that conversation. I apologize for that. And we would, I'm going to leave that mistake in. Normally, I would say I'm just going to go and edit that out. Ilya Somin, professor of law and a fellow director at the Cato Institute. Thank you so very much for joining us today.
Thank you for having me. Great questions.
Thank you. And this brings us to the end of yet another Lunch Hour with Federal Newswire. I'm your host, Andrew Langer. Enjoy the rest of your lunch.
This has been the Federal Newswire Lunch Hour Podcast, hosted by Andrew Langer. Check out the Federal Newswire's family of websites, as well as their social media stream.